The first case that we'll be looking at this week is the Taylor and Johnson case. But this is a key case for unilateral mistake as to terms or facts. And it also does come up in relation to common mistake. Okay, so in terms of what happened in Taylor and Johnson, in this case, Johnson granted an option to Taylor for him or his nominee to purchase 2 adjoining 5-acre lots for $15,000. And Taylor exercised this option and nominated his children. A contract for sale of land was entered into between Mrs. Johnson as vendor and Taylor's children as purchasers. And then later on, Mrs. Johnson refused to proceed with the sale, despite having signed 2 documents, okay, which had the sale prices $15,000. She refused to proceed with the sale on the basis that she believed the purchase price had been $15,000 per acre, as opposed to $15,000 in total, okay? So according to her, the price of the sale was $150,000 because there was 10 acres, not 15,000. So a significant difference there. Now, and that the interesting thing as well in these facts is that the market value of the time of the sale was actually $50,000. So yeah, so Mrs. Johnson thought she was selling for $150. The land itself was worth $50, but she signed the contract for $15. And Taylor's children sought an order for specific performance. So they sought to have the contract followed through with, to have it performed. So to have Mrs. Johnson sign the title transfer documents, okay? And then Johnson instead pleaded that the contract be set aside. Okay, so in terms of the key issue here, the issue before the High Court was whether a unilateral mistake by Johnson as to the price had been established. With regards to the decision, the High Court majority of Mason, Murphy and Justice Dean, with Justice Dawson dissenting, and we'll come back to Justice Dawson's dissent later in our case reading guide questions. The majority of the High Court found that specific performance of the contract be refused on the basis of the unilateral mistake made by Mrs. Johnson. So here, the mistake operated, I guess, as a defence for Johnson, so she didn't have to go through with the performance of the agreement. Refusal to order specific performance being one of the equitable remedies that are potentially available. The majority held that the written contract for sale of land was voidable, okay, in equity, since Johnson was mistaken as to a fundamental term, the price, and also significantly, which we'll come to when we look at the case reading questions in a moment, significant part of this finding was that the Taylors had actually acted unconscionably in full knowledge of the mistake, okay? That was just to give a brief overview of the case. So we'll have a look now of what was held, okay? So we'll come back to this again, but contract, the key points to take away is the contract is voidable in equity. Okay, so the common law not relevant here. It's not a common law rule, it's an equitable rule. And the elements are, so when a party is seriously mistaken about some aspect of the contract, okay, and the other party deliberately sets out to ensure that they do not become aware of the mistake. In that instance, the mistaken party may avoid the contract. And just remember from what we've discussed earlier about unilateral mistakes as to terms or facts, that second element, that the party deliberately sets out to ensure they do not become aware of the mistake, is needed, okay? The mistake of itself doesn't mean you're entitled to equitable relief, okay, for these types of mistakes. So if we go through now the case reading guide questions that I had there for you, the first one was around who's suing whom for what. In this instance, Taylor is suing Johnson for specific performance. They want that land at the value of $15,000. And here Johnson has cross-claimed seeking rectification or an order setting aside the contract. Now, the rectification action part of the case was actually dropped or abandoned by Johnson, and we'll come back to that in a later question. And here she was ultimately successful in getting the order setting aside the contract. Yeah, and as noted, just previously, in equity, a court can refuse to order specific performance when there's been a mistake made. Okay, and here the mistake prevented sale going through. Okay, so in terms of the mistake, as noted, it was a unilateral mistake as to price. It mentions here that there was an option in favour of Johnson, which was exercised by Johnson's children. So what is an actual option? An option is an agreement to sell at a particular price, and then the purchaser has the option to choose whether they purchase the property or not. And Mrs. Johnson here, as mentioned, signed 2 separate documents containing the mistake. In terms of what kind of mistake did the court say this was a unilateral mistake as to the content of the contract, so as to a term in the contract, the price. In dissent, Justice Dawson thought it was a mutual mistake as to content, which you'll see when we get to the Dawson judgment. That was to do with the fact that the trial judge had believed Taylor that they weren't aware of Mrs. Johnson's mistake. So in that instance, it was seen to be a mutual mistake, but that came down to how Taylor's evidence was received by the trial judge. But yeah, unilateral mistake as to content. Yeah. Okay, in the High Court judgment, at paragraph 428 to 429, there's discussion of the subjective theory of contract as well as the objective theory. Okay. And the majority goes through the fact that the subjective theory implies that there's no contract at common law. And then because equity follows the common law, the result would be that the contract would be void. However, the majority note their preference for or the persuasiveness of the objective theory of contract. And under that, the contract is voidable for this type of mistake, which is what was found ultimately. Yeah. If you're interested in these different theories of contract, have a look at paragraphs 428 to 429. According to the trial judge, did Taylor know about Johnson's mistake? As mentioned, the trial judge believed Taylor that they didn't know of Johnson's mistake. But the Court of Appeal and the High Court found that that awareness was present, and that not only was it present, but they'd actually taken steps to stop Mrs. Johnson finding out about that mistake, which is part of the reason why, or was the reason why, that sharp conduct was the reason why the unilateral mistake was found to have big grounds for the contract to be set aside here or voidable here. Note as well Justice Dawson's support in dissent for the trial judge's treatment of Taylor's evidence. In terms of the ratio, the contract was set aside on an equitable basis because there was that fundamental mistake of fact, awareness of the mistake, and actions, and some action was taken to make sure that the other party, Mrs. Johnson, didn't become aware of the mistake. And the actual quote is from paragraph 432. Where it stated that a party who entered into a written contract under a serious mistake about its contents will be entitled in equity to an order rescinding the contract if the other party is aware that circumstances exist which indicate that mistake and, most importantly, deliberately sets out to ensure that the first party doesn't become aware of the mistake. Okay, so moving on then to Question 8. So what is the difference between this ratio and the position in America? In the US, rescission is actually permitted, so contracts can actually be voidable even when the material mistake was innocently caused by the other party. However, as noted already a couple of times, in Australia, that sharp conduct or element of unconscionability is needed for equity to set in and then the contract to be voidable. And this is then important for that next question. If Taylor knew that Johnson had made a mistake but allowed her to sign without saying anything, would her mistake case have succeeded? Well, the answer is most likely probably not, okay? The reason being is that affirmative conduct, that deceptiveness, that level of unconscionability is needed. So silence there would generally be interpreted from that objective view to be okay. All right. So some affirmative action is needed under these principles relating to unilateral mistakes to be successful. So in relation to the next question then, so if Mrs. Johnson had signed the contract knowing the price was $15,000, but Taylor knew it was worth significantly more, would a case for mistake succeed? In that instance, the mistake would be with regards to a fact, so it's the value of the property. And in that case, no, the contract wouldn't succeed. Because the mistake of making a mistake of itself, as we've learnt so far, isn't enough, okay? So something else is needed on behalf of the other party. Number 11, so can you imagine any circumstance in which the fact of the mistake itself should excuse a party from a contract? There's only really one that comes to mind here, and that's with regards to mistakes as to the nature of the documents. A unilateral mistake has two documents. The doctrine is around non est factum, it is not my deed. And in those instances, the mistake is to the nature of the document rather than the contents of the document, so rather than the terms or facts on which the terms are based is made. We'll come back to non est factum when we look at Peddlin and Cullen in a separate video. With regards to the next question, so the majority refer to the view that in the absence of fraud or misrepresentation, resort must be had to equity to escape from a contract on the ground of unilateral mistake. Of this, they say, whether that proposition should apply in the case of an informal contract or where there is a mistake as to the identity of the other party can be left to another day. Okay, it would seem that it does not apply where the mistake is as to the nature of the contract. So what they're referring to here is cases of non est factum. Okay, in that instance, it's not the equitable rule that's relevant, it's the common law rule. So the contract is void, not voidable. And then the back half of the quote, so for the present, we are prepared to accept it as applicable to a case such as the present, where the mistake is as to the content of a formal written contract. So when the mistake is made as to a term or a fact, so the content of the contract, it's the equitable rules that apply where the contract will potentially be voidable as long as the other elements, as outlined in the ratio, met. Okay, and the court also leaves open cases as to mistakes as to identity, which may or may not be voidable depending on the circumstances, and we'll come back to that in the case of Pappas and Bianca. We've got two more quick questions. First one is, Mrs. Johnson abandoned her claim for rectification. What do you think of the merits of that claim? Okay, well, with regards to that, there was no meeting of the minds. Okay, so here it's not an instance of both parties kind of being mistaken and discussing a term, and then in the process of it being drafted, it was changed or omitted or something else was added. There's no correction of the record needed because Taylor wasn't under the same misapprehension as Mrs. Johnson. That's why rectification is seen as not appropriate. And if you compare this case to the Liebler case, in that instance, there was clear evidence of negotiations regarding the amendment of the term, and the solicitor just made a mistake, and the term was deleted rather than amended as the parties requested. So here, there was no evidence of negotiations that it was actually supposed to be $150,000. So that's why rectification is not appropriate. And finally, why did Justice Dawson dissent? We've spoken about this a couple of times so far in this video. This essentially just came down to an unwillingness to overturn the trial judge's treatment of Taylor's evidence. Justice Dawson wasn't prepared, I guess, to reinterpret Taylor's evidence like the Court of Appeal and the majority judges who found that Taylor actually did know that Mrs. Johnson was operating under a mistake to the price of the contract. So because of that, Justice Dawson didn't want to overturn the finding that Taylor was not aware Johnson was mistaken and therefore based their dissent around that. So base the dissent around Taylor being, I guess, a believable witness who didn't knowingly encourage Mrs. Taylor's misconception as to that mistake that she made. Okay, so that'll do for Taylor and Johnson.